few seconds. We are just adjusting the student actually, and then we can start the session.
Right.
So may we start?
Yes, surely.
Thank you, sir. Good evening, everyone. On behalf of the organizing committee, I extend a warm welcome to all the participants joining us for this online guest lecture series. Today's session focuses on a very significant and timely theme, which is mediation and settlement in commercial disputes. It is indeed an honor to have with us Shri Vinay Kumar Khanna sir, a master trainer since 2009 under the aegis of Mediation and Conciliation Project Committee of the Honorable Supreme Court and a distinguished judicial luminary. Without further ado, I now invite Shri Vinay Kumar Khanna sir to address the gathering and enlighten us with his valuable thoughts and experiences.
Thank you. It's indeed my privilege and honor to join the student and the faculty. I mean, today's topic is mediation and settlement in commercial disputes. So I think the audience are the students, and I understand they have the basic understanding of what mediation is. But for their benefit, I'll tell them, start with the basics. Mediation, you know, who is the mediator? We have to understand who is the mediator, what is mediation. It is now mediation, what mediator does, how we do it, why mediation is there, and then commercial disputes. What are commercial disputes? and then the role of mediation and settlement in commercial disputes. So mediation, as we know, it is a flagship of the ADR mechanism, alternative dispute redressal mechanism, we know. And first of all, I'll start because in every society, you see, there are disagreement disputes. They would be there when society, and our society, 150 crore people, there are bound to be disagreements, difference of opinion and dispute in the society. And that's why there's a need of dispute resolution mechanism. Traditionally, we have that litigation court system we have, but it was felt by all when in all systems we used to hear that justice denied, speedy justice. Then speedy justice is a part of Article 21 of the Constitution. Everybody expects why there are delays, etc. So then the movement of alternative dispute redressal mechanism is started, ADR started. And we know we see our statutory recognition, Section 89. In 2002, Section 89, read with Order 10, Rule 1A, CPC. Then Salem Bar Association case in 2003. I'll just give a brief background. Then AFCON's Infrastructure versus Sharian Workis case, 2010 Supreme Court. I will not go into all that today. I understand you must be aware. And if you are not aware, please read all these Salem Bar Association case and AFCON's infrastructure case. That is now history. Now we have moved too far now thereafter. And then you see in the context of commercial dispute came this Commercial Courts Act 2015, wherein this concept of pre-institution mediation in commercial dispute came in. But Act had come in 2015, but rules, pre-institution mediation rules were framed in 2018. And then it started. So this Commercial Court Pre-Institution Mediation and Settlement Rules 2018, which are called PAMS Rules 2018 came. And also side by side, there were amendments in Companies Act also. Now, for example, Section 37, 38 of the Consumer Protection Act we have, which refers to the mediation section. Then in Krishna Murthy's case versus New India Assurance 2019, Supreme Court felt the need of a comprehensive legislation. And now we have Mediation Act 2023, which is now some of its provisions have come into force, and the rest of them regarding Mediation Council of India and other provision will come into force. And then you'll see this mediation. Now the time has come and you'll see the earlier like litigation. Now you as a student will see that mediation as a career. Mediation advocacy will come into picture now. Because so far we had only code annexed mediation, wherein a referral judge will refer a case to the mediation center which have been established in the district courts, high courts, Supreme Court. So there only the mediator will assist the parties, record the settlement, it will go to the court, and then under Order 23, Rule 3 CPC, court will pass a decree or dispose of that case as settled. But now you will see service provider, mediation service provider will come into play, where they're not only institutional but ad hoc mediators, private mediators, not only lawyers but in other fields of experts will become mediator, and this mediation service provider will be recognized by the Mediation Council of India, and then the settlement which is which takes place with the assistance of this mediation service provider or the mediator, will have the decree will be enforced like a decree of the court. That is the difference we'll see now. So with that, you will see in the time to come, there will be separate stream of mediation where as mediation advocacy and council would do only mediation, like some of them do only arbitration. So it has been felt that this mediation has become very popular. Why it has become popular? And why it has become immensely popular? And because it is satisfying. There's a win-win situation. In litigation, in arbitration, there's one person who wins, other loses. In mediation, it is a win-win situation. No one wins, no one loses. That is the beauty of mediation. And the parties settle. And the other thing is, other advantages of the mediations are that this is a flexible process. It is a cost-effective. And main thing is the parties themselves decide. Here, mediator is not a judge. He will not decide for the parties. We say self-determination. They themselves decide. Because mediation is a assisted negotiation. Now, two disputing parties sit across the table and mediator assists them. I'll tell you briefly about how he assists. You must have read it, or I'll briefly touch upon that also. First is, what is mediation and why mediation? And other thing is that not only that mediation is there, it supplements other form of litigation. Now, as I mentioned, that disputes are there. Why there are disputes in society? Difference of values, belief, interests, or there's a breakdown of communication, poor communication, misunderstanding, there's a power imbalance, or cultural, some resource competition. All these things lead to disputes. And then dispute have to be resolved. So mediation has now become a very popular and one of the flagship of the ADR mechanism, as envisaged under Section 89 of the CPC. Now, how it takes place? So we say mediation is a structured process. It is an art and science because it has stages. In the beginning, I think for your benefit, I can take up there's rules. If we see, I was mentioning about Commercial Code Pre-Institution Mediation and Settlement Rules 2018. That also prescribes the procedure in what manner you have to do. But before I go to that, firstly, you must know also what is commercial dispute. Because mediation can take place in family matters, it can take place in interpersonal disputes, and it can take place in commercial disputes. Now, what is commercial dispute? Commercial disputes, if we see commercial disputes are defined in Commercial Code Act, if you see Section 21C of the commercial definition of commercial dispute, it defines all sorts of matter, ordinary transactions of merchant, bankers, financiers. They are commercial dispute, export or import of business, issue relating to carriage of goods, supply of goods, construction, infrastructure, franchise agreement, joint venture agreement, consultancy agreements, shareholder agreements, mercantile agency, and all these things, partnership agreement, technology development agreements, agreements of sales of goods and provision of services, contract of agency, insurance, intellectual property right, IPR matters. And these are, I think there are 23 categories provided under Section 21C. You please must read Section 21C of Commercial Code Act 2015 to understand the definition of commercial disputes. Then you will know the scope of commercial disputes. And then also there is a category 23 which says central government can notify any other category also apart from that 22 category. If a dispute comes in within that category, we say it is a commercial dispute. Now, commercial disputes to come within the definition of Commercial Court Act, of course, specified value has to be there. It is 3 lakh now. If it is more than 3 lakh, the case can come to the state court. And of course, up to after 2 crore, it will go to the High Court, original side. So that is a commercial dispute. Now, in the Commercial Court Act, Section 12A has been added, which says that before you file a commercial dispute, you have to exhaust that remedy of pre-institution mediation. Now, what does Section 12A says? A suit which does not contemplate any urgent interim relief under the Act, Commercial Court Act 2015, it shall not be instituted unless the plaintiff exhausts the remedy of pre-litigation mediation in accordance with the procedure which has been prescribed therein. Now, what is the procedure prescribed therein? That anyone, claimant, anyone who thinks he has a dispute, commercial dispute, will file an application. Now, central government has notified legal service authorities, secretaries, now in Delhi Legal Service Authorities as nodal officer. They will move an application before the DLSA and deposit certain fees which is given in the schedule, and thereafter nodal authority will issue a notice to the other party, and then other party comes, then a mediator who are empaneled with the court and with the mediation center, it will be marked to him. Then mediator parties will appear and mediator will assist those parties to arrive at a mutually acceptable solution. Now, if a defendant does not appear after issuing notice, then in that case, that nodal authority, DLSA, will provide them a non-starter report. And then they will attach that report with the suit, and then only they can file. Unless, of course, they can show that urgent relief is granted, is required, is contemplated under the Act. Now, regarding this urgent relief also, now recently, Supreme Court has clarified that what is the scope of that urgent relief. Because what was seen was that as soon as some provision comes, now we find certain ways to bypass that. So what was happening was that the people, the council, they were just mentioned that we file some application seeking urgent relief. For example, under Order 39, Rule 1 and 2, or under Section 40, Punishment Receive or anything. There might be urgent, but it was found that in most of the cases, either non-starter report was coming or urgent relief was sought. But now, if you see, you can note down 1, 2, 3 cases. The Supreme Court, you must have read the case of Patil Automation's case, Patil Automation Private Limited versus Rakheja Engineers, 2022 Supreme Court. Supreme Court held that Section 12A of the Commercial Court Act is mandatory. And if a party does not exhaust that remedy, the suit can be rejected under Order 7, Rule 11 CPC. But still, I think there was still a dispute regarding urgent relief. And then you see one case, the Jamni Manohar's case, and then one Dhanbad Fuels case this year, Dhanbad Fuel Private Limited versus Union of India, wherein two-judge bench of the Supreme Court held that test under Section 12A is not whether prayer for urgent relief actually comes to be allowed or not, but whether on examination of the nature and subject matter of the suit and cause of action, the prayer for urgent relief by the plaintiff could be said to be contemplable when the matter is seen from the standpoint of the plaintiff. So it was further held interim relief must not merely be an unfounded excuse by the plaintiff to bypass the mandatory requirement of Section 12A of the Commercial Code. And now recently, a few days ago, it was 27th October now, 1 week ago, Supreme Court in Novenco Building and Industry versus Zero Energy Engineering Solution, after referring to those cases, held that the tests which can be distilled for the purpose of rejection of the plaint and adjudication of interim relief, you have to mention, and you can read that para 20 of that judgment, that section 12A mandatorily requires pre-institution mediation for commercial suits, and non-compliance of which would already render plaint defective, institutionally defective. And a plaintiff can be exempted from the requirement of section 12A only when plaints and document attached with it clearly show a real need for urgent interim intervention and wholesome reading of the plaint. Therefore, the plaint has to be read in a wholesome manner, and the material annexed to thereto, plaint should disclose the need for urgent relief. So the court must look at the plaint, pleading and supporting document to decide whether urgent relief is genuinely contemplated. And the court can look also for immediacy of the peril, irreparable harm, risk of losing right, assets, statutory timeliness, perishable subject matter, or where delay would render eventual relief ineffective. It was held a pro forma or anticipatory prayer for urgent relief, which is used as a device or skipped mediation, will be ignored, and the court can require parties to comply with section 12A. And the court is not concerned, because at this stage we have to see, court is not to concern with the merits of the urgent relief, but only if the relief sought seems to be plausibly urgent from the standpoint of the plaintiff. And the only then court can dispense this under requirement under section 12A. Therefore, what is the now intention of the legislature is that mediation, pre-institutional mediation is mandatory. You cannot bypass. And that is a policy of law now emerging. And otherwise, if we see in section 89 ADR, mediation is becoming most popular. It is the flagship of the ADR. So, I have mentioned about that section 89, FCON judgment, these rules. Now, under Companies Act also, now by virtue of Mediation Act 2023, section 442 has been added, where it is mentioned that the parties can apply for mediation in any case which before the NCLT, where companies matter are there, or court of its own motion can refer to mediation. So these are the statutory requirements now. So now the point is how in commercial disputes, how a mediator should conduct. As I mentioned that mediation is a flexible process. It is a process where parties themselves determine the outcome. Mediation is he has to maintain the confidentiality, which is the heart of the mediation. Confidentiality, you know what is confidentiality now? That a mediator is not supposed to divulge what happens in mediation to the court, which referred the matter, or what parties disclose to him. Because now, if you know the basics of mediation, as I mentioned, it is a structured process. When parties appear before the mediation, why we say it is a structured process? Because it has stages. In the beginning, when parties appear before him, he introduces himself. He tells to the parties what is mediation, what is benefit, what he is going to do. He'll tell to the parties he will not decide. You themselves would decide. He'll set the ground rule for the parties. Look, these are the ground rules. Because here, in any dispute, you see, there are persons and problem and positions. We say 3P. Because there are persons, it can be individual person, it can be juristic person. and there is a problem. That is why parties have appeared before the court or before the mediator, and they have taken positions, and there is a dispute that has to be resolved now. So what mediator does is, when mediator is there with that flexible process, because the strict rule of evidence and arbitration do not apply, he, with his skills, transforms the dynamics of conflict. How he does it? As I mentioned at the beginning, introduction, and then he understands the disputes. What is the dispute before him? What is the nature of dispute? He understands the issues. In that process, because parties now understand that they are in the safe hands and atmosphere is conducive for resolving. Because parties who have taken the positions and defenses now, slowly, gradually, they start leveraging their actual interests, the cause of dispute. Then the mediator understands not only the dispute but underlying interest of the parties. In that process, both parties also understand each other's perception. They hear each other. And what are the tools before the mediator? Tool is communication, his neutrality, his expertise, his credibility. And with that, he slowly, gradually, parties understand each other's perception and also each other's version. Because parties have expectations which are unrealistic. Because they are under dispute and they think they are right. Suppose it is now in a commercial dispute. It is a dispute over money. It is a dispute for supplying of the goods. And one party says that, look, goods you have supplied, you have there is a less supply, or the goods are defective. Other party disputes that. So when parties sit across the table, they understand each other's perception. Then slowly, gradually, mediators start understanding their interest, parties start their interest. In the beginning, there is a joint session. He holds a joint session where he understands the disputes and party understand each other's version. Then he takes separate session, which we call caucus and separate session, where he sits separately with the parties or with their advocates. Also, in commercial dispute, you see there would be a lot of persons. There might be technical experts, there would be financial person, there might be other persons. So first thing mediator has to understand is that persons who are across the table have the authority to take decision, authority to understand and then take a decision. Therefore, first thing he has to do is he has to design that process, because he has to control the process. Parties will control the outcome, but he will control the process. How he does, as I mentioned, initially he sets the ground rules. He tells to the parties, understands the disputes, and then slowly, gradually, parties understand each other's version and they start divulging the actual real interests they have. And in the private session, he does that brainstorming session with the parties, how they are going to lose, how they are going to win, what is the strength of their case, what are the weaknesses of their case, in a dispute, in any dispute, as I had mentioned in the earlier session also, that there are three types of needs we have: substantive needs of the parties, procedural needs, and psychological needs. Once those procedural needs are met, that process design has taken place, and parties are satisfied that, look, here is a expert mediator who will assist us and who has expertise to assist us, and and it will be fair, and it is their own decision. He is not a judge, he is not like an adjudicator, like in an arbitration or in the court. He is here only to assist us. We are negotiating and he is assisting us in arriving at a mutually acceptable solution. So mediator is facilitating only negotiation. He is assisting parties to arrive at a mutually acceptable solution of their own. But neutral, he is neutral like a judge. He will not decide, but he is neutral like a judge. Then in those brainstorming sessions, parties will understand when he will have that reality testing, but we say reality testing. There he sits across the parties and tests, makes their expectation realistic. That look, this is your case, this is the law, these are the facts, these are the issues now. Now, what is the dispute? What is your underlying interest? This is the interest. Then he understands, then slowly, gradually, parties start exploring options. They start moving towards the solutions. There can be one or more than solutions. For example, if I give you an example in a intellectual property right case. Now, one party says that there is an infringement of his IPR. Plaintiff. Now, who is the defendant? Defendant is manufacturing certain goods which are spurious. Now, this plaintiff is actually not manufacturing himself. He had actually a lot of other manufacturers who were manufacturing for him. Now, in court, he has filed suit for infringement, passing off, and damages. Now, if the court would pass order, court can restrain. As on the first case, 39 order 39 1 and 2, court will hear the arguments, and then court will restrain. If court is satisfied there is existence of a prima facie case, irreparable injury, balance of convenience, court will restrain. And now that person during mediation, after this case has now come to mediation, after mediator has heard both the parties, it is found that, look, here is a fabricator who was making goods infringing the trademark of the plaintiff, but plaintiff has so many other. Then a innovative solution, creative solution, which we say is another beauty of mediation, cropped up, that this defendant now will actually make good for the plaintiff, because his goods were so good, that is why he was able to infringe, mislead people, because they were so resembling the plaintiff's good that he, as a fabricator, now he became a supplier actually. After when the solution was found, this defendant became a supplier for the plaintiff. Now, this you see is an innovative solution. In court, you will see in ordinary traditional adversarial system, this will not take place. Case will go on and either court will restrain him or compensation would be awarded. But this thing that defendant becomes a supplier for the plaintiff in commercial dispute is something, what we say, creative solution. Now in mediation, we also say that relationship is restored. Now these two parties had a strained relationship. They were not seeing eye to eye. This person, even a criminal complaint can be filed and other. But he actually became a supplier for the fabricator for the plaintiff. And it was a win-win situation. Win-win for the plaintiff because this person had imported machinery from outside of crores of rupees. That is why he was able to duplicate those goods and had now hundreds of employees which he had employed. Otherwise, they would have become jobless. So it was a win-win situation for as a whole, for plaintiff, for defendant, and for the economy as a whole also. Because when we say now in the context of commercial dispute, we say why speedy disposal should take place. Because in business, if I am a businessman, I am doing common industry, I can't afford time in resolving dispute or going to the court. So I would like to dispose of that suit at the earliest. And the mediation, as a mediator, that solution is being provided to him. And other thing is confidential process. Now you will come across many times there are disputes which are now we are coming, technology, source codes are there, a lot of other confidential nature of disputes are there. Now employees, we are coming across dispute where employees who are privy to those source codes or certain technological things or trade secrets will start their own, and then this dispute here, that dispute remains confidential also, and solution is found. So if you see now in commercial dispute, I had given you definition of commercial disputes. So these are mostly the dispute which will come apart from IPR regarding terms of the business, performance of agreement, the goods are not supplied, breach, infringement, confidentiality breach, shareholder directors dispute, and agreements. And now you will see that in contracts, like earlier arbitration clause used to be added, now the mediation clause will come. Because now we are coming across this concepts of med, med and all that. There is a combination of where before a case is referred to arbitration, even courts are saying you exhausted remedy of mediation. Like in commercial dispute, we have 12A. Otherwise also the clauses which are coming, there firstly you exhaust that remedy of mediation. Now you have MSME Act, Micro and Small Enterprises Act. There is section 1819, if you see, it speaks about conciliation. That counsel is there, MSME counsel is there before the case is referred. So now there is an amendment also to that act by virtue of Mediation Act. So in all cases, you will see that mediation has come to stay and it will grow. So we can't, now without mediation, it will not be a possibility. And it will take place a chunk of the dispute resolution mechanisms. So now the first thing I mentioned that in commercial dispute, mediator, what mediator will do, how he will behave differently than other types of dispute. In family matters, you see, we have dispute where is a different ball game. And one more thing, mediator, when he looks at the facts, he doesn't look the same way as an adjudicator looks at the facts or a judge looks at the fact. His view is more broader because even he can go beyond the relief, beyond the dispute. So therefore, mediator, apart from that, first thing I mentioned about that process, he has to control the process. That gives a trust to the parties, credibility to the party. Second thing is development of his soft skills. Now, how to say, when to say, because there would be times when in commercial dispute, there would be deadlock, stalemate, impasses. Now, how to break that impasse? Because perceptions are different, parties' perceptions are different. Therefore, he has to utilize those soft skills. Soft skills, as I mentioned, active listening, paraphrasing, and you'll come across a host of those skills. In what manner things have to be said, changing the messenger, because same thing, if suppose party will tell to each other, then parties may not accept when they come in a different way, because it takes that toxic element from that conversation, and he rephrases that, paraphrases that same thing. So he is focused attention, his mindfulness, those listening without judgment, active listening and being aware and treating parties, because you see in commercial dispute, businessmen would be there, CEOs of the parties would be there, big parties would be there. He has to treat them with respect and dignity. And confidentiality has to be maintained. And he has to connect with the party. Only then he will be able to understand and assist the party. And last but not the least, the patience. Mediator, as a mediator, you will come across that, look, parties are at deadlock. I can't help you. But you can't raise your hand. You have those skills. You, with patience, you are like a symphony master. You are like a catalyst who will change the dynamics of the conflict. So that you will see the mediation advocacy has come to take place now. Those argumentative skills now, of course, they would be required in the court, but here those soft skill, mediation advocacy skills, those skills will be more. So mediation has become such a powerful tool now that my understanding is now in all corporate coming time, there would be a mediation clause. And your role as a mediator will be on the rise and you can't do it. Of course, now, like in the court, we have been doing now through video conferencing or hybrid mode. So I've been empaneled as a mediator in Supreme Court. I've been doing it in a hybrid mode also. Online, suppose one party has to come from Ahmedabad or one is at Delhi, then party at Ahmedabad, we are doing it through hybrid mode. Of course, there are certain challenges of that also. You have to deal with that. A good connectivity has to be there. Then you take the parties to the separate room. And like here we do it physically, we have parties go out of the room. There also you have separate rooms where we have the separate session with the party and then they come to the common room like that. All these things, of course, but we have to be take into account the technological factors into that. But even that hybrid mode and online mediation has come to stay now. Because parties, you will see in commercial mediation, international mediation, parties will be across the border also. Some parties sitting at Singapore, some party at Indonesia, some at US, and one party in India, and you are suppose here. You are doing through online mediation. So you have to be aware of all these things. And then, of course, India is a party to the UN Convention on Mediation and Singapore Convention. Of course, it has yet to be ratified. So as a mediator, we have to understand that you are not only assisting the parties, you are like a healer, a peacemaker, I say. And that satisfaction level which you have as a mediator would be higher than as an advocate. It is my experience now. I've worked as a judge, I've worked as a counsel, I've worked as a mediator and arbitrator, but I found that when only recently one family matter in Supreme Court I assisted in settling. The parties had so many other cases. So it gave me more satisfaction comparatively than the other modes. So it was a win-win situation. All cases came to an end and parties were happy. So their relationship was restored. Same way this happens in commercial disputes. Relationship is restored once parties settle their business relationship continues and maintain. That is another beauty, and that is good for economy also, ease of doing business also. So we have now, from my view is that as a student, as a advocate, you have to start developing that interest and the capacity right from this time, because not only in India but worldwide, the future of mediation is very bright, and therefore you have to understand all this intricacy. And I think now time will come, then even at this level, those 40-hour training can be imparted. And recently only, and under the aegis of MCPC, uh, I was as a senior master trainer, we imparted training to the DRT judges and the senior this chief general managers of banks across the India. Because now it is felt not only advocate can be mediator, all other experts, chartered accountant, those were the chief general manager recoveries who deal with those cases of recovery of cases, banks cases, when the bank account becomes NPA, etc. So even there is a one circular of the Ministry of Finance that all those public sector undertaking, etc., will give priority to those mediation also first. So only I think it's a matter of days or months that Mediation Council of India will come into place, and those mediation service provider will be recognized. And therefore, as mediator in commercial dispute, I understand we have a bright future, and that is what I'll say. Therefore, you keep yourself aware of this. That is all I'll say at the outset, and now we can have some interaction.
Srishti, please ask for the questions from students.
Okay, ma'am. Thank you so much, sir, for this insightful session. Now we will open the floor for questions from our participants.
Yes, you are audible.
So you are
Sir,
mute.
you are on mute right now. Sir, are we audible? Sir, you are on mute right now.
Oh, yes, I am. Okay. If I have understood the question correctly, it is about neutrality, how to maintain the neutrality, right? Right? Okay. By neutrality, you means only that, like a judge, you are impartial. You are not taking sides, right? Of course, you are assisting the parties in arriving at a mutually acceptable solution, and you are assisting the negotiation, but you are not taking sides. You are, of course, when hearing the parties in the joint session or private session, of course, you are active listening, you are hearing with empathy, yes, but you are not taking sides. Confidentiality is another attribute we say is the heart of mediation. where one party is supposed says something, tells something to you, and then only with the consent of that party we reveal that to the other party. That is one part. And second part is to the court, it can't be disclosed. One party, when the matter reaches to the court, and it is in the old model. In the new model, it will you will not have to approach to the court for passing decree. Because in the old model, it is a court annexed mediation. Once mediator decides, because that mediator's mediation settlement is not binding so far, it has to go to the court, to the referral judge, who would then record the statement, satisfy himself or herself that parties have settled, then would pass a decree under Order 23, Rule 3 CPC. But in the new model now, which is coming, private service providers, so as a mediator, if you are recognized with the Mediation Council of India, you will record the settlement, then it will be enforced as a decree. So regarding neutrality, you have not to worry. I don't think you need any psychological sessions for that or otherwise. We know what do I mean by being impartial. I have not to take sides, and that slowly, gradually, that your credibility will be established. That look, here is a mediator. She is neutral. She has expertise. So that is as simple. I don't think there's any rocket science about neutrality, right?
So you are muted.
Yes. As a you you are neutral. I think you have only thing is you have not to take sides with the party. Of course, we are human, and but we as a mediator we have not to think who is right, who is wrong. Parties have taken certain stands, certain positions, and slowly, gradually, they have understood each other's interest. We are just assisting them, and they are doing all that. We are just understanding, making them understand each other. Look, here's a party. For example, in a commercial dispute, one party says I have to pay rupees 10 lakh. Other party says I have to take 25 lakh. Then there are documents, there are facts, there is a law which you know that look, these are the documents, these are the receipts, these are the invoices, and if the goods are defective, etc. Again, there are mainly commercial dispute you see would be based on documents. It is not like a family matter. Of course, in family matter, there may be something like that, what transpired, that happened in the closed door, etc. But they're also from parties' mouth, and then we focus on the things which matter. Right. But in commercial disputes, you see, dispute would be about the terms of the contract, about IPR, about all those definitions which we have mentioned. And then with the training, slowly, gradually, I think you can come across that. You can cross that. I don't think that would be a difficulty. It's a matter of just time and experience that you have that, acquire those skills. Thank you.
Anyone else from the audience side who wants to ask question?
What do you think? Yes. One thing is that you have to be accredited as a mediator. now the system at present, the system is that if you are a lawyer, then you have to get that training of 40 hours training as a mediator, and then you have to do, after that training as a mediator, then you have to do certain successful 10 successful mediation. You will sit as a co-mediator with some mediator. Out of 20 and 10 have to be successful. Thereafter, you would be certified as a mediator. And then, of course, once you are with some mediation service provider, even private, which soon will have, which is registered with the Mediation Council of India, then you can start practicing as a mediator. Right?
Anyone else? Sir, I guess all the questions are answered. So can we conclude the session?
Yes, if there are no other questions.
Thank you so much, sir. Thank you once again for your time and invaluable insights. We are deeply grateful for your continuous guidance and contribution to promoting the culture of mediation in India and abroad. I also thank all the attendees for their active participation. We look forward to seeing you all in our next session for this lecture series. Have a wonderful evening ahead. Thank you so much, everyone.
Thank you. Thank you.
Thank you so much, sir. Thank you so much.
Thank you. Thank you.